about the Supreme Court and the influential role its decisions have played, especially in the past half century, widening the gap between rich and poor in this country. At least that's the central thesis of Adam Cohen's new book, Supreme Inequality. Adam himself practiced law for a time after graduating from Harvard. He worked as an attorney for the Southern Poverty Law Center and later for the ACLU. Then he went into journalism, first as a senior writer for Time magazine and then as a member of the editorial board of the New York Times, where his editorials focused on legal affairs and technology. Over the past decade, he's gotten into government, serving as a special policy advisor to Governor Andrew Cuomo of New York, and more recently as a speechwriter and then policy advisor to Mayor Bill de Blasio of New York City. This is Adam's fifth book and his second about the Supreme Court. His first three were about Mayor Richard Daley of Chicago, eBay, and FDR. His last book, Imbeciles, was about the history of eugenics in America and specifically the 1927 Supreme Court decision, since largely repudiated, that supported the forced sterilization of intellectually disabled citizens and others considered unfit, arguably for the good of the country. In Supreme Inequality, Adam examines the Supreme Court's steadily conservative bent over the last 50 years. He recalls how under Earl Warren, the court served as a powerful force for equality and inclusion, protecting the rights of workers, criminal defendants, and voters, and attempting to outlaw race discrimination. But in the wake of Warren's departure in 1969, Richard Nixon appointed 4 consecutive jurists in 3 years, setting the court on a rightward course. Its rulings in such areas as campaign finance, voting rights, poverty law, and criminal justice, Adam contends, have favored corporations, narrowed individual rights, and limited class actions, in the process greatly exacerbating economic inequality in our country. The book has received a number of favorable reviews, commending Adam not only for his lucid writing style and richly detailed narrative, but also for the broad and compelling sweep of his argument about the injustice done by the court to the American ideal of protecting the vulnerable. Adam will be in conversation with Peter Edelman, a law professor at Georgetown University, where he's been on the faculty since 1982 and teaches constitutional law and poverty law. Peter also is the faculty director of the Georgetown Center on Poverty and Inequality. Additionally, he's done several stints in government, managing to serve in all 3 branches as a Supreme Court clerk, a legislative assistant to a senator, and a counselor to a cabinet secretary. Plus, he's written several books, including a couple on poverty and one on Robert F. Kennedy. So Adam's going to come up and talk a little first about his book and present some slides, and then Peter will join him. So please join me right now in welcoming Adam Cohen.
Thank you for that very kind introduction. Let me start by saying what a pleasure it is to be here at Politics and Prose. This is not only, of course, one of the nation's great bookstores, but it's also a center for ideas and discussion, civic engagement, just the kind of institution that enriches our society and all of us. So to be here and to be part of this is really a great privilege. It's also a great privilege, of course, to be here with Professor Edelman. You heard a little bit about him. Of course, you know so much about his career, which had him working with, names like Arthur Goldberg and Robert Kennedy and Bill Clinton. But for people like me who inhabit the world of this book, he's also a great hero in the poverty law movement, both because of what he did when he served for President Clinton, which I'm sure you all read about, but also because of his amazing scholarship on welfare rights, which I cite extensively in the book. So I'm really honored and grateful that he agreed to join me here today. I wanted to start with just a few slides to give you an idea about the book, and then we'll talk about it, but we both know the book, and you all may not. So just to get across the main ideas of it. And To start, some of you may have seen this image. It went very viral a few weeks ago on Twitter. And what it was is CBS Morning News did an amazing segment where they went to a shopping mall and they set up 5 plates. And the 5 plates represented the 5 different income levels in our society. The highest 20%, the second highest 20%, third, fourth, fifth. And they asked just people in the shopping mall how they should distribute this piece of this pie that has 10 pieces to accurately reflect how wealth is distributed in our society. And of course, everyone was wildly off. You know, people were embarrassed when they said, well, I think the highest plate should probably get 4 slices of pie. And well, you know, it's not 4 slices of pie at all. The top 20% in our society get 9 slices of pie, or 90 out of 100. The second 20 get 8. The third get 2, and then the fourth and fifth plates, you know, as the correspondent said, the fourth plate gets a few crumbs, and the fifth plate gets a bill because they're in debt. And what was fascinating about this report was 2 things. One is, of course, you know, we can't see often enough just how extreme the maldistribution of wealth in our society has become, but also the fact that no one had any idea, right? You ask average Americans, and they know it's a little bit unequal, but they have no idea how unequal, and that was very clear from that segment. So the question is, we've all heard that we live in this society with large and growing wealth and income inequality. Why is it? We hear a lot about larger forces like globalization and automation, government policy, but people often talk about things Congress has done or the president, like the Bush tax cuts. What we don't hear a lot about is the Supreme Court. And the reason I wrote this book was to try to shine a light on that and say, if you look at the Supreme Court in the last 50 years, it has been a major driver of our wealth and income inequality, and no one talks about it, and no one blames them for it, and no one holds them accountable. So how do we know that to be true? Well, let's start by saying what the court is, and this will also explain why it's a 50-year book. We had a very different court 50 years ago, the Warren Court, which I'm sure a lot of you know about, a liberal court that was actually doing a lot of things for poor people as well as for racial minorities and religious minorities and others. Nixon was elected in 1968. He came in with a promise to create a different kind of court. He said he was going to create an anti-Warren court, a conservative court that would do things very differently on civil rights, on criminal defendants' rights, and also on poverty. And he was wildly successful. First thing he was able to do is he was able to replace Earl Warren, the liberal Chief Justice, with Warren Burger, who had promised Nixon that he hated the Warren Court as much as Nixon did, and he was going to change everything. And then, in my book, I make a great deal about this man, who I think is unfortunately not well remembered now. He was really the Merrick Garland of his day. So why do I say that? Because Abe Fortas was the most liberal member of the Warren Court, and he was good friends with Johnson. Johnson nominated him to take Earl Warren's place, and he would have become the next Chief Justice. The Senate rejected him for a number of reasons, some of which had to do with some ethical issues, a lot of which had to do with the fact that Southern Democrats did not like the things Fortas had done in civil rights. Republicans in the Senate were hoping to hold the seat open, so if Nixon was elected, he could fill the seat. Anyway, Fortas is not elevated from Associate Justice to Chief Justice. But then, when Nixon comes into office, he sees that Fortas is vulnerable, and Nixon is trying to get as many seats as he can to change the court. So, as I describe in the book, he engages in a lot of dirty tricks, really unethical, illegal activity. He threatens Fortas with criminal prosecution for something Fortas did in association with a foundation that was not criminal, didn't violate any court laws. He also threatened Fortas that the Justice Department would go after Fortas's wife, who had been accused and cleared of a different criminal matter related to her law practice. So there's a lot of pressure. The Nixon administration is leaking all this to the press constantly. There's a very, I think, unethical and wrong meeting between John Mitchell, Nixon's Attorney General, who later himself goes to jail over Watergate crimes, and Earl Warren before he steps down as Chief Justice. Again, putting the pressure on Fortas to step down. Fortas does step down, and that creates a vacancy for Nixon to fill. So and it's because Fortas leaves that Nixon's able to get 4 justices in 3 years. He gets Warren Burger, Harry Blackmun, who for quite a while was a conservative. We remember him as a liberal now, but that took a while. And Lewis Powell and William Rehnquist. And we get the Nixon Court. Over the last 50 years, the membership of the court has, of course, changed. Liberals have come and conservatives have come. Liberals have gone, conservatives have gone. What we've had for 50 years, though, has been a conservative court, a conservative Chief Justice, Warren Burger, William Rehnquist, John Roberts, with a conservative majority behind them. Think about how odd that is, because think about in the last 50 years, the presidency has gone back and forth. We've had Clinton, we've had Obama, we've had Reagan, we've had two Bushes. We've had Democratic majorities in the Senate and House and Republicans, but the court has for 50 years been a conservative redoubt. So, as I said, the question is, why would we blame this 50-year court for the rise in income inequality and wealth inequality? Well, there was a report, the World Inequality Report 2018, done by Thomas Piketty and other leading economists, that looks at inequality around the world and why there's inequality from country to country. In the United States, they say there are two main drivers of inequality: educational inequality and unprogressive taxation. Well, each of these is absolutely attributable to that Nixon court, the court of the last 50 years. Educational inequality is extreme. The Washington Post a few years ago looked at one state, at Pennsylvania, and they found the highest spending district spent 3 times as much as the lowest spending district. And this is replicated in many states across the country. The Supreme Court had an opportunity to end that disparity in a case called Rodriguez v. San Antonio School Board. And in fact, the movement at the time was very strong to say that the Equal Protection Clause said when the government acts, when it provides public education, it has to do so equally. All the kids in the state have to get the same kind of education. The lower court ruled that exact thing. Many other lower courts around the country and state courts were ruling that. Law professors were writing law review articles saying that's the way things should be. The Supreme Court 5-4 says no, says Texas can continue to unequally distribute money so that the rich kids get more than the poor kids, and 5-4. So of course, if Abe Fortas had not been wrongly, illegally, diabolically removed from the court by Nixon, it would have been 5-4 the other way. And then another case, Milliken v. Bradley, did a similar thing, ensuring that we couldn't have true racial integration in the North. Again, 5-4 would have come out the other way if Fortas had been there. So the other part of what the World Inequality Report pointed to was the lack of progressive taxation. We all know that the top rates on the wealthiest have been going down, down, down. Well, why is that the fault of the Supreme Court? Well, because actually the people would like higher taxes on the rich. That's shown in poll after poll after poll. The people who don't want higher taxes on the rich are the rich, and they are major campaign contributors, right? So this is an article from, you may remember when the Trump tax law was being voted on in late 2017, there were a lot of stories where actually big contributors were not shy about it. They were saying, Republicans, unless you lower our taxes, we're going to stop giving you campaign contributions. And Lindsey Graham actually said, look, if we don't get these lower taxes through for the wealthy, we're going to lose, financial contributions will stop, and a lot of incumbents are going to lose their seats. Okay, so why is this the Supreme Court's fault? Because starting in 1976, we get a line of cases, the campaign finance cases, that made up this idea that money is speech and money is protected by the First Amendment. It didn't have to be this way, and in fact, when Buckley versus Valeo was first heard by the D.C. Circuit, one level below the Supreme Court, they upheld the campaign finance laws at issue here. And the campaign finance law was a good, strong law that had been passed in response to the Watergate scandal, in response to the outrage of the American public. The D.C. Circuit said, no problem, no First Amendment violation. The Supreme Court strikes down the expenditure part of that, opening the floodgates for money to enter the political system, and they've opened them more and more and more and more. We all know Citizens United, they finally opened it to corporations as well. So those are the two main things that I would say are the main drivers of the Supreme Court having an impact on economic inequality. But there are many more, and I talk about them in the book. They've been anti-union, anti-worker, and discrimination cases. They've done a lot of things to help corporations increase their bottom lines, having to do with class actions, punitive damages. They've exacerbated the mass incarceration crisis, which is an economic inequality issue as well. So final thought I want to leave you with in this is just to say that, it didn't have to be this way. This was a politically constructed court established by Nixon. There was one theft of a seat that started it when they took Fortas' seat. another that continued it when they took Merrick Garland's seat, and if Merrick Garland had been allowed to be seated, we would have ended this. We'd had the first liberal court in decades, but we didn't get that. In the book, one of the heroes is a guy named Ed Sparer, who was the father of poverty law and a professor of poverty law and also a poverty lawyer himself before he went into academia. And he said after one really terrible decision that ended the welfare rights movement, Dandridge v. Williams, that if it had gone the other way, it could have been a different America. And I think that's a really important point to keep in mind, because we could have a different America, but the Supreme Court has given us this one. So that's my little summary.
Well, what do we do next?
We talk, we chat, we talk.
All right, you talk.
Okay.
Well, I'll just say one thing to start with, which is Adam asked me to write something for the book, and I would have read it anyway, but
Okay.
I had to.
Okay, you did.
And I just have to tell you, some of you have already read it. It's really terrific.
Thank you.
And the basic point you've already heard, but just to add, at least for a lot of, you didn't hear anything I said? I'll start over. That this is Washington, and there's a lot of lawyers here and so on. But I think for a long time, Brown and Roe v. Wade and so on gave the court, shall we say, too much that everybody thought it was terrific. And this book tells us differently. So I think we know this question, but we always start with these things. Why did you write this book?
Oh, okay. It's a good question.
Oh, good.
No,
hit a good one.
As you may know, because she was supposedly feeble-minded, but the court not only said that, but it actually really embraced the eugenics movement and said we need more eugenics, we need to save the country from being drowned in a tide of imbecility. So this was a terrible decision, but when I was done with that book, I thought, the same idea that they side with the strong over the weak and they really run rampant over the rights of the vulnerable has been true in the current court. It's been true for the last 50 years, and I think that was an important message to convey. So really, when I was done with writing about the historical court, I thought, let's really apply these same ideas to the current court.
Mm-hmm. And you did it.
Thanks.
Let's go back. You really covered so many things over the condensed version, but very effective. So let's start with the Warren Court and dig a little bit deeper. What did we lose when we lost that court? What about that era was so important?
Yeah, the Warren Court was a very special era in our country. So we think of it mainly from its first decision, 1954, Brown versus Board of Education, or a decision in Warren's first year. Very important, of course. But then in the 60s, it really gets going in a lot of different areas, right? Cases like Miranda, where they rule that you have a right to be told that you can remain silent if the police are questioning you. Cases like Gideon, where you have a right to a lawyer if you can't afford a lawyer. And then a whole set of political cases. And, when Warren was asked at the end of his career what decision he was most proud of, a lot of people thought he would say, of course, Brown versus Board of Education, his most famous case. But he said it was actually the Baker v. Carr line of cases, because those were the cases that struck down badly districted legislative districts. And he thought that was so important because unless people can speak through the political process fairly, then we don't really have a democracy. So I'd say that was another critical part of it. And then finally, of course, what they did for poor people, which has completely changed how we view them.
Mm-hmm. I might say, since I clerked for Arthur Goldberg, I always tell the story a little different in the sense that he comes before Fortas, and if you look at the numbers, it goes 5-4. In that we're clear that everything's liberal at that point. Fortas definitely continued, but
Yeah.
I have to get that in. So let's go a little bit slower than what does happen. I mean, you certainly caught very much the highlights, but slow it down. We do Fortas is as you said, they do bad to him. He made a mistake, but they got him, and so it starts there. So do it a little bit more full.
When you read the memoirs of people like John Dean and John Ehrlichman, the people who were around Nixon, it's amazing to see just how obsessed Nixon was with the court and with taking it over. So he was counting noses constantly, and he was looking at the court, on a daily basis to see who can I get off of it? He was asking for regular reports on the health of members of justices. He was, and Warren Burger was delivering them. There's a famous episode where Thurgood Marshall finds out that Nixon is asking about his health when he's in the hospital for something, and he says, you can tell him how I'm doing, but you also have to tell him, I'm not dead yet, and I'm not going anywhere. So Nixon is really keeping an eye on all this, and then when he sees this opening with Fortas, it just played to all of his strengths and John Mitchell's strengths, which was, really skullduggery, right? I mean, they were working closely with the Justice Department, which is not supposed to happen, right? The White House is not supposed to be coordinating with the Justice Department. They're telling them, as we're seeing today, right? It's a distant mirror, huh? So, but they're doing that very closely, and really everyone understands that the reason for this is to get that seat. And yes, as you mentioned, Fortas made a few missteps, and the one they were going after him for was his relationship with the foundation, the Wolfson Foundation, which, it seems to us odd today that a member of the court would, as Fortas did, accept a stipend from a nonprofit foundation. He took $20,000 a year to work for it, but it was a civil rights foundation. It worked on civil rights and religious tolerance. For the book, I talked to his law clerk from that year, '69, when he was removed from the court, and that law clerk told me that Fortas really thought that he was doing good work by working for the foundation. What happened, though, is that Wolfson was in trouble with the law, ended up going to jail, and the Nixon administration tried to suggest as hard as they could that he was paying Fortas so that Fortas would help him stay out of jail. But there was never any evidence of that. Fortas never got involved in the criminal case. And the thing is, although it sounds odd now, other justices were also taking money from foundations, were doing other outside work. So again, I wouldn't praise what he did, but the idea that he should be removed from the court for it was really outrageous.
So that's really is the kind of the turning point.
Yeah.
Let's go through. I do want to also do more about poverty because you and I both are. That's what we care about a lot. But okay, Fortas is gone. Berger's there. You mentioned, of course, some of the cases there and what they did do, and so we got some of that. But take it more deeply. Now we're in the 70s. When you actually know what's going on, which the book does for us, and for some people it's new, younger people, and so on. So get us going.
Sure. So on the poverty front, the book opens with a case called King v. Smith, which is a remarkable case. So there's a woman in Selma, Alabama, who is struggling. She is on welfare, but welfare is not very much those days. She's also picking cotton in the fields and working in a diner, like starting at 3 a.m. to support her 4 kids. Her husband's dead. So she's doing all this and then barely scraping by. And the welfare officials call her in one day and say, we're taking away your welfare because, we found out that you have a boyfriend. People have been talking about this. And, it's, again, hard to imagine now, but back then, many states had what were called man in the house rules. If they could show that a boyfriend was visiting you, even if, as in the case of Ms. Smith, he didn't visit very often, and he had his own family and his own 9 children, and he was not really supporting her children, but they took her welfare away. And almost everyone in her situation would just kind of roll over and say, that's the way it is. She really was amazingly brave. She challenged it in court all the way up to the Supreme Court. The Selma political establishment, the white establishment, as you might imagine, were not very kind to her. It was hard for her to get groceries and food on credit, and just her life became very difficult, but she didn't give up. Gets to the Supreme Court. She wins 9-0. The Supreme Court strikes down the man in the House rule, and as many as 400,000 children around the country are benefited by that ruling. So that's an amazing thing. And I start with that case because it gives a flavor of what the Warren Court was doing, really going to bat for the poor people who were being mistreated. And there are many other cases like that. And it all culminates, of course, in 1970 with Goldberg versus Kelly, which is, anyone who's been to law school has spent some days on this case. But it's so important, where unbelievably, when we think about the current court, that court, and it was by then just the beginning of the Burger Court, said if any government office is going to take away someone's welfare, they must give them a formal hearing first to make sure that it's being properly taken away, because welfare benefits are that important. So that's an amazing thing that they read that into the Due Process Clause. But so there were a bunch of cases like that Smith case, like Goldberg versus Kelly, that were really, the court was standing up for the poor. And then 2 weeks after Goldberg versus Kelly, it all comes crashing down with that Dandridge case I mentioned, where that was a case, it was a challenge to a welfare cap in Maryland by a woman who had a large family, and she's on welfare, and they pass a cap where they say we're not going to give any extra benefits after child number 4, and the cap was so low that large families like hers were plunged very far into poverty. And there was a very good equal protection claim saying that, and a statutory claim saying that those later children are entitled to benefits too. You can't just say because you're later in birth order you don't get any benefits at all. The Supreme Court not only rejected that, but they used language that really said, we're done with welfare rights. We're done with, second-guessing government when they make these decisions. We're out of this business. And really that ended with a thud, this movement that had been going on for a decade to try to, improve the lives of the poor.
We might just add on King v. Smith, that was the first time that there was a decision about welfare, about the 1935 statute, and there had never been a Supreme Court case about it.
Wow.
Between 1935 and 1968. So it just underscores what you
Yeah.
said, that they took that. And the other point, which just to add to what you said, there were some earlier cases, but this was the really kind of hot time because of who the court was. So between 1968, which was the time that was the high point, and the whole thing crumbles in 1970.
Yeah.
It's just amazing that there was that very. And you mentioned Ed Sparrow, which I actually yesterday I had a speech in Fordham, and I met a man. I never met Ed Sparrow, even though I was alive in there. But I met a man yesterday who was a pal of Ed Sparrow. So that the man that touched the man.
Yeah, that's great. That's great.
that was terrific. So they really believed, Ed and the others, that they were going to get the court to decide that there is a constitutionally required amount of money.
Right. And in fact, I nearly started the book. In a draft I did, but then I changed course. But with Frank Michelman's famous Harvard Law Review, it's hard to believe now, but Frank Michelman, who's still a professor at Harvard Law School, wrote a famous foreword to the Harvard Law Review Supreme Court issue of 1969, where he said, when you look at the Equal Protection Clause, there's an argument that there is a right to subsistence under it, and that everyone has a right to a certain minimum level of support from the government. And amazingly, the New York Times actually ran a story saying, maybe there's a right to subsistence, and got a lot of law professors saying there was. So it was really, people were moving in that direction, but it was just after the Warren Court was over, so it was really too late. They were saying maybe we could go in this direction, but already Nixon had taken over the court, so it wasn't going to happen.
Yeah. Well, we can go a lot of directions here, and so are we finished with the 60s?
I think so, yeah.
Oh. Well, maybe somebody have a question.
Okay.
It was such a nice time. Well, it was terrible in some ways, but as we know. there were both the wonderful and,
Yes.
and the absolutely horrible. But we've got a lot of decades to cover.
We do.
So can we get you to talk about the 70s?
Sure. The 70s is, as I say, the beginning of that sharp turn, right? Where you get, it is amazing, as I say, that within 2 weeks you get the best welfare decision in history, Goldberg, and then the worst, Dandridge. And really, Dandridge in 1970 really starts the trajectory, and the court then begins to pull back on a lot of the rights it's already created. And then also in 76 you get Buckley versus Valeo. So what you see is the poor really begin to fall in the 70s and the rich begin to rise.
And well, you could say some more. Washington versus Davis. There are other bad things that
there was a lot of terrible stuff, but I just feel there. Well, I feel there are a lot of decades we have to get through though. Yeah. Well, I mean, they do some positive things for civil rights at the beginning, right? Yeah, but then yes, they do begin to turn on civil rights as well. Not sure what I would point to. Maybe we should move on to the 80s.
Okay. Well, we can do that.
Okay.
So,
Yeah.
oh,
Okay.
well, I'll tell you what. No, this I think we're going to get your own experiences, but that's in the 80s.
Yeah.
So,
Yeah.
all right. Let's see what he says about the 80s.
Oh, the 80s. Okay, so I'm glad you asked me.
After the 70s comes the 80s.
I'm so glad you asked me about the 80s. Yeah, no, as you point out, one reason the 80s are important to me is that I was just graduating from law school and moving into a public interest career that I had been, formed by the Warren Court, and that the Warren Court was why I went to law school, because I thought that's what the law would be. And then when I graduated from law school, it was already Berger moving on to Rehnquist, and so a lot of the things that I thought we'd be able to do with public interest law, we no longer could. So I was actually at the Southern Poverty Law Center in Alabama, and then in the national office of the ACLU, where we had a race and poverty unit. But when we thought about doing welfare rights work, you run into Dandridge so directly, it really prevented the federal courts from doing much. And then I did a lot of work on some school cases, particularly a big school case in Alabama where we were trying to equalize school funding. So we represented poor children in the Black Belt of Alabama around Selma and places like that. And we had to operate under the state constitution because that Rodriguez case had absolutely wiped it out. And
that was in the 70s.
That was
When I couldn't
70s.
get you to talk about the 70s.
Oh, okay, but so the 80s though is where we're trying to remedy it by going into state court. Yeah.
Okay.
So we're in state court and we actually win in the Alabama state, the lower state court. We win a very good verdict, but it goes up to the Alabama Supreme Court, which is very conservative and overturns the decision. So it does a Rodriguez-like thing and says there's no right to equality. So these were the kind of obstacles that we faced in state court. But what I didn't realize when I was doing this, and I spent years on the cases, I didn't put together till I started working on this book, just the degree to which the reason we were driving around in that car and signing up plaintiffs and trying to bring this in state court, and one of my co-lawyers, Eileen Hirschnov, is in the audience somewhere. She was in the car too. The reason we had to do this is because Abe Fortas was removed from the court. If he had been there for the Rodriguez decision, we wouldn't have had to try to convince the Alabama Supreme Court. But so that was my experience in the 80s, was the frustration of running up against a very different kind of poverty law.
Mm-hmm. And more broad, you have, as you said, the beginning of what's happened to money and the whole question of elections. Yeah. So maybe a little more depth on that, and because you got two things going on. You've got other things. I mean, you've got corporate stuff in there, yeah, and other pieces to the people on the rich side.
Yeah.
And what we had here in the 60s, we saw that people really cared for the people on the bottom, and that in the 60s, not so much happening on the top, and then it just gradually goes so that completely flip-flops.
Yeah, and I do keep coming back to the campaign finance cases because, there's one law review article that said that decision in Buckley versus Valeo saying that money is speech is the original sin of, our constitutional law, because once you say that money is speech, then really you change from a democratic form of democracy to one, an Ayn Rand form in which money buys everything. And there's no reason for it. The DC Circuit decision that I mentioned quite rightly said that money wasn't speech. And, I like to think of it as the Supreme Court had a case once years ago where someone was challenging a city law on noise trucks in the street, and there were decibel levels and all that. And they said that law against amplification was a violation of the First Amendment rights. And the Supreme Court rightly said, no, you have a right to speak. You don't have a right to speak at an unlimited number of decibels, late at night and wake up all your neighbors. Well, that's exactly the way they should have viewed the campaign finance cases, right? You have a right to speak, but you don't have a right to speak at $1 billion. And if we're regulating the $1 billion, not the words you're saying, we're regulating something like amplification. We're not regulating your speech. And if they had done that, again, we'd have totally different politics. And of course, we're seeing in this presidential election, imagine how different things would be if there wasn't as much significance to being a billionaire when you run for president.
Do you ask yourself whether some of the people who were put on the court on the conservative side turned out not to be so conservative? And so I could sort of push back a little bit, even though the trend was certainly from the 70s going on, it was moving to the right. But there's a bunch of people there from Powell who's mixed. But anyway, we can say the names.
Yeah. Harry Blackman is, of course, the big example. Where Blackman starts out as one of the two Minnesota twins. He was appointed by Nixon because he and Warren Burger were old childhood friends from Minnesota, and he voted with Warren Burger very much in those early years, and then ends up writes Roe v. Wade and becomes quite liberal at the end. Yeah, that does go on, and it's not to say that everyone's staying exactly the way they are, but somehow it remains a 5-4 conservative majority. And one thing, the Republicans are just so much better than the Democrats at maintaining that majority. And they do it in so many ways, but one way they do it is the passing on of seats, right? I mean, when Anthony Kennedy stepped down, he appeared to be in perfectly fine health, but he stepped down at the last moment he could be sure that there would be a Republican President Trump who had a guaranteed Republican Senate that would confirm his successor, and that's when he stepped down. Ruth Bader Ginsburg and Steve Breyer could have stepped down in the Obama administration when there was a Senate majority, and they didn't. And I'm not saying that what they did was wrong, but I'm saying Republicans consistently are very careful about building that majority and keeping it. Democrats less so.
So let's you did this some in the initial part of our being here, the 5-4. What if? Different 5-4.
Yeah, a lot very different, right? So if Dandridge had gone the other way, if the court had not said, we've stopped caring about poor people, we're not going to second guess the government in what it does, we might have a very different, more robust poverty law. You write in a law review article about the possibility of, just imagine if the court, which was playing around with the idea of maybe saying that the poor were a suspect class, imagine if they had said that. There are a lot of policies, a lot of ways in which the poor are badly treated that might be vulnerable to challenge legally if they were a suspect class, the way racial minorities are and religious minorities are. But there are other 5-4s as well, and Milliken v. Bradley, the case I alluded to, that's a case where Detroit schools were becoming so intensely segregated. The NAACP wants to integrate the Detroit schools in the late 60s, early 70s, but there literally are no longer enough whites in the system to make that possible. They've all fled to the suburbs. So the NAACP says, well, we need to have an intra-district remedy. There's no reason that we can't mix kids across the urban-suburban line. And this federal district court judge in Detroit, Judge Roth, ruled that there could be a metropolitan area remedy, that there had to be, in fact, and he worked out a really nice remedy where they sliced up the Detroit metropolitan area like a pie, and every district he created, it was no longer Detroit and then the ring of white suburbs. It was slices of pie where each slice had a racial composition that reflected the overall composition of the metropolitan area. So they would all be districts that were about 70% white. And that could have worked, right? It wasn't that, that idea that, people used to scare people, if we're going to send these suburban kids into the inner city school by themselves, we would create new integrated districts for everyone. 5-4, the Supreme Court overturns Judge Roth, and again, it's because of Fortas. Imagine if we had had that kind of an idea of integration, and if you combine that with Rodriguez and also said everyone gets equal funding, imagine what we would have after decades and decades of every kid in America getting an equal education.
And notice that those are all about around 1975. And Roe takes place in that same frame. So people say, oh, the Supreme Court is really great. We've got Roe v. Wade, which is important, and of course. And people just didn't pay attention to the fact that all these things that are about race and poverty and education, and they're going the wrong direction. And Linda Greenhouse has also written about this, that particular time. But it's so important to understand that people were looking in the wrong direction about that. Other 5 and 4s as you go to the 80s, or other things that you want to add to the 80s there?
No, I think we've kind of covered the 80s.
Oh, okay. Well,
I'm worried about letting other folks get in some questions. Also,
okay, well,
honestly.
let's do that. But do you want to say anything about, maybe this is so obvious, which is, where is the Supreme Court going?
No, it's obviously a critically important point, right? Some of you may have heard that there's a presidential election going on, and this one, we've been saying for a while. We said in 2016, the most important one of our lifetime, but this one is for so many reasons, but very much the Supreme Court, right? I mean, we had a change when Kennedy left and Kavanaugh arrived, right? We don't know how dramatic a change, but conservatives have never been happy with that particular conservative Supreme Court because they always felt that Kennedy wasn't reliable, and on gay rights he would sometimes break rank, and even on a few race cases. They were convinced that by getting someone like Kavanaugh in, they would have a solid 5 votes to maybe do very extreme things like maybe rule that all affirmative action is unconstitutional. So maybe we've already had this kind of major shift, but that remains to be seen. But the next appointment, if Trump gets to replace in a second term Ruth Bader Ginsburg, for example, we may be talking about much larger things. I think it's hard to see how Obamacare would be upheld with another Trump appointment, for example, but even other parts of the whole New Deal edifice. So this is a really, really important election for the court, and what's very disheartening to a lot of us is no one's talking about it. It's not coming up at the debates. It's not, the candidates aren't talking about it. They should be talking about it all the time and relating it to things like healthcare. We understand that healthcare is a major issue for voters and for swing voters, and one that helps liberals in this election. Well, you need to remind people we can have the best healthcare law in the world, but if we don't have the Supreme Court that will uphold it, you're going to lose your government healthcare. So it's really, really important.
Okay. Well, how about some questions?
I've got one.
Okay.
Piggybacking on the point about the election and everything, one of the things that I think liberals don't really understand about how we've gotten to this moment with the conservative judicial supremacy that we have is that conservatives spent 40 years creating an infrastructure to educate, build an entire legal community around originalism and these very conservative ideas through the Federalist Society and whatnot, and then also educating their voters about the importance of the court to their decisions about who to vote for. I mean, I know many people who are Republicans who don't like Donald Trump's personality, but they love his judges and they will vote for him regardless of anything else because of the judges that he will appoint. Whereas liberals don't care. But I guess that's just my comment. I don't really have a question. It's just that it really annoys me.
Thank you. That's good.
Your annoyance is duly noted. Well, Mark Twain famously said, "I'm not a member of an organized political party. I'm a Democrat." Right, and I think that applies very much to. Sorry, Rogers. Thank you. Exactly. Good to be in this audience with this audience. So the point still stands, and that very much applies to the way the Democrats have handled the Supreme Court. There is, of course, there is a group that's a counter to the Federalist Society, right? The American Constitution Society, and you may have seen that Russ Feingold just was appointed the new president. So I think people feel that may inject some new energy there, but absolutely, the ACS and liberals need to take a page from the conservative book and push back as hard in the other direction. But great point.
Good. Other questions? comments?
Oh, hey,
Sure. I have a question. Hi, Adam.
hey, Mike.
You talked a lot in your speech about kind of the outcomes of these decisions. Can you just talk a little bit about the legal reasoning of the conservative majority? And do you, in your book, outline areas where you disagree with it? You talked a little bit about, money versus speech, but, it's possible, I suppose, that, the Supreme Court could be right on some of these issues. And so can you just talk a little bit about the legal, because you're not looking for outcomes in a sense, but
Yes.
for sound legal reasoning.
It's a very fair point. And right, a lot of people might say, well, right, maybe they're just required under the law to reach these decisions that are consistently horrible to the poor and the weak and helpful to the rich. Maybe that's just the way, it's like the opening scene in Rosencrantz and Guildenstern where they flip the coin 76 times and it keeps coming up heads each time. So maybe that's just, it's the way it is. But when you look at the reasoning, I do talk about it in the book, case by case. But like, take the case in which the Supreme Court struck down a key part of the Voting Rights Act, Shelby County v. Holder. So that was such an extreme thing to do, right? So the Voting Rights Act is one of the most revered laws in American history, right? It was the culmination of the civil rights movement. It had enormous bipartisan support. It's been reaffirmed, because it had to be reauthorized repeatedly, by bipartisan majorities in Congress, signed by President Reagan and President Bush at various reauthorizations. The entire country has been behind it. Now, when the Supreme Court approaches any law, we heard Chief Justice Roberts say at his confirmation hearings, he thought he should be an umpire, call balls and strikes, right? So he should be reluctant to overturn any law that's passed by the Democratic branches, and then particularly one that is so central and so supported by the entire range of opinion. So you would want to be very delicate before striking down that law. So what did they actually do? They strike out the heart of it, the preclearance requirement, and if you read the reasoning, it's such a made-up reasoning. He talks about equal sovereignty of the states. After that decision came down, Judge Richard Posner, who is a conservative Republican appointed by Reagan, wrote in Slate magazine that he had never heard of the doctrine of equal sovereignty of the states because there isn't such a doctrine. So there are other examples like that. If we could say, when you actually look at their reasoning, they had no choice. They didn't want to strike down the Voting Rights Act, but in fact, it's quite the opposite, where you look at what they do, and you can't even see why they did it. Another example is Affordable Care Act, right? They got a lot of applause from certain quarters when they upheld the Affordable Care Act. Less attention was paid to the fact that they struck down Medicaid expansion. The Medicaid expansion would have provided health care to millions of the poorest Americans, would have literally saved lives of many of them, because we know the correlation between early death and lack of health care. So there too, you would expect them to be very careful about striking down. The ground on which they did it, that it violated the spending clause, is so implausible, and it's not one that the lower courts had ever adopted, and really no one had really thought about. It sort of comes in at the last minute. It seemed very clear when you read it that Roberts was feeling, I would say, conflicted about turning his back on the conservative majority and wanted to throw a bone to the other side. So those are two examples. But if I looked at all their decisions and said, look, I got to hand it to them, they have ironclad legal reasoning behind their decisions when they turn against the poor, that would be one thing. But I promise you, they don't.
So I have a question as a non-lawyer. Besides buying and reading your book, how do we follow, as a citizen, how should I be following the Supreme Court? Because you're talking about nuances of the Supreme Court decisions, and that's not something I read. Do we all need to be reading them and understanding them? Like, how can you track basically how things are changing?
It's a great question. I would say, though, that we're living in a golden age of legal reporting, right? I mean, there are so many great places to read about what the court is doing, including Linda Greenhouse writing in the New York Times, including SCOTUS blog, including other places like that. And we're actually at a point, I think, where it's amazing how ubiquitous the bad decisions are, right? Like, you begin to regard like reading about the Supreme Court as like the obituary page. You don't want to see what they're saying that day. And just the other day, right, there was that horrible decision where the Mexican parents were suing, right, because their 15-year-old child was, playing on one side of the border, shot in cold blood, and the court 5-4, let us emphasize, says that they cannot sue. So I think a lot of it is there, but it may also be getting lost in the general fog of horrible news everywhere. And that's why within inequality, there's so many terrible things going on. I wanted to shine a light and say, let's really think about what the Supreme Court is doing that's horrible. But I would say when you flip through, the terrible news in your newspaper or on your computer screen, pay special attention to the terrible things the Supreme Court is doing, because they're there. But thanks for the question, Daniel.
Adam, thank you so much for your book. I've been waiting for it.
Oh, thank you.
And it's the first book in my life that I've been waiting for.
Oh, wow.
And I'm a voracious reader.
We may use that quote on the paperback.
So, I'm not a lawyer, so I apologize if it's a basic question, but suppose that someone is running a liberal state or a liberal city, right? And we have the Supreme Court that is currently there, but how is it possible to address the issues that you are talking about at the state or city level?
So if the Supreme Court remains conservative, how can we
drive liberal agenda or progressive agenda at the state and local level?
Yeah, no, it's a great question. So there's first of all the things that can go on at the city level and the state level being done by governors and mayors, and there's a lot of that, right? Like we see the Supreme Court as being terrible on immigration, but we see a lot of cities have declared themselves to be sanctuary cities, and are in New York City, where I live, we created a special municipal ID NYC, so that undocumented people can have some form of ID that they can use to go about their lives, which is incredibly important for them. So we're seeing a lot of that policy at the city and state level, which is really important. But the other thing is what I alluded to in the Alabama case. State courts have their own powers that are absolutely separate from the federal court system. So when you get a ruling like Rodriguez, which I mentioned, where the Supreme Court says under the federal Constitution, the Equal Protection Clause, you do not need to fund rich and poor districts equally, states can reach a different conclusion. And Thurgood Marshall wrote a dissent in Rodriguez where he actually said, said a lot of things about how sad the majority decision was, but he also said, let's remember, states can do their own thing here. States can reach different conclusions under their constitutions. And that was actually the injunction that people like me at the ACLU were using when we went to Alabama and said, we're going to sue under the Alabama Constitution, or we're going to go to Louisiana and sue under the Louisiana Constitution. It's not a full substitute because, well, first of all, you can lose there too, as we did in Alabama, but also it's a lot more work because you suddenly have to bring 50 cases all around the country and then you have to try to enforce the ones you won, legislature by legislature. So it's not as good as a national rule like we got in Gideon saying every state has to provide and every city has to provide a right to counsel. But there are these ways around it. So I think absolutely the more we're getting rejected at the federal level, we need to think of these state and city solutions. So it's a really important point.
Hi there.
Yeah.
Thanks so much for the book, and thanks for being here. I'm interested in your views on some of the campaign finance decisions, including Citizens United. I kind of have two questions. The first being, what do you make of the argument that, even if Citizens United would have gone 5-4 the other way, candidates like Mayor Bloomberg would still be able to self-fund campaigns, and it would really just lead to more wealthy people, especially those that are affiliated or own media companies, from entering politics and kind of controlling the political narrative. And the second part being, what do you see as the legislature's responsibility in kind of addressing this problem under the constraints imposed by Citizens United?
Yeah, great question. So, when people say, Citizens United is, the big problem, and if you want to change the world, change Citizens United. As you're alluding to, it's not the whole problem, right? I mean, it was a very visible problem because it extended a whole new set of rights to corporations. But this has been an ongoing thing going back to '76 in Buckley versus Valeo. So what you really need is, if you had that idea that money is not speech, you could have regulations that would include individuals spending their own money, right? There's no reason Congress couldn't say, no one can spend more than $2,000 in an election, or $5,000 or $10,000, including the candidate, right? And the reason we don't have that is it's so clearly not constitutional now. But that if we, so this was done incrementally, where many different decisions, struck down different campaign finance rules. But if we went back to square one and just said money's not speech, Congress can regulate all of it. They can tell Mayor Bloomberg he can only spend, some small amount of money. That would be great. And the question is, how do we get there? The problem is Congress can't do anything. The state legislatures can't do anything as long as the court continues to say what it says. So that's why people like Hillary Clinton have been talking about a constitutional amendment. And, that's a really, really high bar. I think it's difficult, but that's the movement I think we should be focusing on. Whether or not we can get there, just to sort of crystallize that, until we go back to overturning the 1976 decision, we're stuck in a world in which money is just way, way too important.
Thank you.
Good evening.
Hi.
So you've talked about education and campaign finance, et cetera. I was wondering if you could talk a little bit about the arc that you see in Supreme Court cases in housing, it being another important factor affecting poverty and inequality.
Yeah. I mean, housing is another area where shortly after Dandridge, there was a decision, Lindsay v. Norman, I think it was, where poverty lawyers were trying to establish that there was some kind of a right to housing. And so in that case, this was a poor family who was living in a really ramshackled house, and they had told the landlady that there were all these very dangerous conditions, and she wouldn't make any changes, and they began to deduct a little bit of their rent in protest of that fact. And under a state law, when they were being evicted, they weren't allowed to say at their eviction hearing, we're not regular people who are not paying our rent because we don't want to pay our rent. We're actually doing this in protest of the fact that we're living in a house that the city has declared to be uninhabitable. So they wanted to use that defense. There was a state law that didn't allow them to use it, and they were challenging that law because they were saying, part of the right of housing is to be able to go into court and say our housing is completely unsafe and we shouldn't have to pay for it. Well, anyway, the Supreme Court handed down this decision that was very much like Dandridge, where they just said, very flatly, there's no right to housing. Housing isn't special. We don't care about housing, all that. And it was very similar to them saying in Dandridge, we don't care about welfare. So after that decision, it made it very hard under the federal Constitution to make housing-related arguments because the court just no longer cared about that. So again, I think it's a route we could have taken. If that had come out the other way, if they had said in that decision, we can't think about this case without thinking about the crucial role that housing plays. And there is, just as we were saying, they could have made the poor a suspect classification. The court could also declare that certain interests are fundamental. And if you have a fundamental interest, that also is a reason that a court is more likely to strike down a law. If they had said that there was a fundamental right to welfare under Dandridge, they could also have said there was a fundamental right to housing under this Lindsay v. Norman, and said, so when there are laws that make it very difficult for people to remain in their homes, we're going to give them a much closer look. They didn't say that. But, at the risk of sounding like a broken record, if Fortas had been on the court, maybe we would have had a different result there. But it's a great question.
And we do have time for this one last
Great.
question.
Hello, thank you for your book.
Sure.
I have a two-part question, and it may be more politics than legal. What are the chances of a president appointing a Supreme Court justice if the Senate remains in the opposite party? That's my first question. And second, even if a Democrat does win the White House this time and they win the Senate, given the fact that there's so many young Republican appointees that now sit on the court, it may be able to protect a Ginsburg-type seat. But is it how likely is it that somehow the number on the Supreme Court would be increased in order to give that majority more towards the liberal end?
Wow, many people accuse my book of being depressing, but I think you've outdone me there. I think all your concerns are completely warranted. I think that if we got a Democratic president and if Mitch McConnell remains in office, I would not rely on him to confirm anyone. I think that's a good thing to worry about. I also think it's very right that that Democrats could win the presidency and we could have this same 5 conservative majority there for enough time to do a lot of damage. So if your goal was to end us on a completely dispiriting note, you've done it. But we were doing a good job on our own, so don't worry.
All right.
Copies of Adam's book are available at the checkout desk up front. He'll be up here signing. Please form a line to the right of the table and help our staff by folding up your chairs. Thanks again for coming.